Good morning.
Good morning.
Good morning.
Hello.
Good morning, everyone. Good morning, Ron. I saw you say it, but we couldn't hear you because you're muted.
Good morning, everyone.
Morning.
Morning.
How you doing, Jeremy?
I'm doing fine. How are you, Ron? It's good to see you.
Good. Good, thank you. Sonny, sorry to hear that you're leaving.
Oh,
Oh my goodness, what are we gonna do, man?
we're in trouble. The institution will carry on.
Oh, geez.
Please, Governor.
Hey, Walker, how are you? Good.
Good morning.
Morning, Gov.
Gov.
Anybody out there?
Good morning.
Yeah, good morning, Gov.
No.
I thought you people up there were frozen out.
Did you get the links, Governor?
Yeah, I did. Thank you.
Great. Those won't expire.
Yeah, let me just ask why that happens, because if
It's
you're
the
gonna-
security feature.
Well, why don't you just send it a little later, like instead of sending it exactly 8 days before, because I review the material and I try to bring them up on my iPad and they're turning.
You're right, sir. My apologies. It's I just wanted to give you advance, as much time in advance as possible when the meeting materials are done. And I thought too, it might be wise to start hosting them on the website just as a thing that like we have a little bit more control over and doesn't have to go through email. And
Okay.
we can.
Well, yeah, if you could just delay the elimination or the termination of the things, send them a couple of days later or something.
You got it, sir.
I'm sure everybody else jumps on them the minute that they receive them from me, but I don't.
No worries. No, and like you said, it's good to have them, at the meeting itself. So even if you review them early, I'll make sure that those links don't expire, so you can use the same one
Thank you.
early on and later.
Okay. It looks to me like we are all met. Sonny, we good to go?
Judge, you have everybody but Stewart, but we do have a quorum.
Okay.
I'll check with Stuart if Jeremy's good.
Here's Stewart.
There we go.
Okay. Then we'll go ahead and call the meeting to order. Call of the roll is typically how we'll begin, and let's do that again today. Commissioner Baker,
I'm here.
Commissioner Bluestone.
Here, good morning, everybody.
Good morning, Stuart. Commissioner Carruthers.
Here,
Commissioner Castillo.
Here.
Commissioner Solomon.
Present.
Commissioner Villanueva. Judy, I saw you.
Oh, there you go. I tried to
There.
unmute myself. Here.
And the chair is present. Thank you. First action item is an approval of the agenda. Is there a motion and a second?
so moved.
Second.
Second.
All right. Is there any discussion of it? Any opposition to approving the agenda? Hearing none, the agenda is approved. Approval of the minutes of the December 3rd meeting, December 3rd, 21 meeting, which was the last one. Is there a motion and a second?
So moved.
Okay. Any discussion? Hearing none, is there any opposition to approving of the minutes of the last meeting as moved? Hearing none, so approved. All right, now we'll move to the meeting items. Item number 1, the legislative update. Jeremy?
Okay, thank you, Chair. Good morning, Commissioners. So there's a few items to update you on with respect to the current legislative session. We're halfway through the current session. As you know, it's a 30-day session. And there's really 4 items to update you on. The first and most important is HB2, the General Appropriations Act. That passed the House yesterday and has moved over to the Senate. It's important to keep in mind that the 30-day session is really about the state getting itself in order as a business entity. The General Appropriations Act is always the most important bill in either session, but in the 30-day session, it really is the focal point, oftentimes to the exclusion of other things. And from that perspective, the commission, we're having a really great session. This is by far and away the best HB2 that we've had as a commission yet. And there's really just kind of 3 points in there that I want to review with you. The first is our Section 4 appropriation for FY23. We see a 26% increase over the FY22 appropriation. The amount appropriated is 1.193 million, and that's 93% of what the commission requested, and it should be enough to fund 8 or 9 FTE positions in FY23. So it's also the LFC recommendation, and it's just very encouraging that the LFC recommended 93% of what the commission requested. It's by far the best that we've done as an agency in HB2. But there's more. The other thing to note is in this HB2, there's a Section 8 compensation increase. All in the current version of HB2 that just went through the House, all state employees are looking at a total 7% compensation increase, with 3% to hit in April and another 4% to hit in July. So that's a really great show of support by the legislature in the state employees, and that's statewide. That's across all classified and exempt employees across the state. And so that includes all the employees here at the commission. So that helps us keep up with inflation. Maybe it helps us do a little bit in terms of our recruiting when we have these new positions come online in July. And then last, there's another kind of piece to alert you to. It's in sections 12 and 13 of the General Appropriations Act. Those kind of sections change from year to year, but these are the sections that allow agencies to make budget adjustment requests, authorizations for budget adjustments in FY22 and in FY23. And so we appear in both, and under these, what we call bar authority provisions, the commission will be able to request budget adjustment increases of up to $30,000 that the commission receives from court ordered judgments or sanctions and settlement payments that are related to commission authorized civil actions. And the commission can move those court-ordered payments or those settlements into its budget for operating expenses. And so that would include, for example, the $4,000 plus that Representative Dow paid in sanction payments ordered by Judge Martin in the 3rd Judicial District. The FY22 authorization would allow the commission to borrow that money into its budget because the commission had to expend money in order to, to forward that piece of litigation, that administrative case. This does not include any fines that the commission itself levies in an administrative case as a kind of a penalty under the statutes that the commission has jurisdiction for. That wasn't requested. We think that's kind of a conflict of interest. And so this bar authority only tracks any monies that a court orders or follows a settlement payment in a commission authorized civil action that we would file in court. So that's an overview of HB2. It's a very good HB2, a very good appropriations bill for the commission. Certainly by far the best that we've achieved yet, and I likely think one of the better ones that we're likely to see in some time. The last thing I'll say about the bar authority provisions is in the kind of LFC notes on HB2, on the General Appropriations Act, there's a note kind of on this bar authority that it follows and is kind of has the same justification as the Consumer Settlement Fund that the Office of the Attorney General has. The Office of the Attorney General, they go and they litigate consumer protection cases for the state. And when they settle those cases, the Attorney General's office can use that money to fund programs and staff that the AG's office uses. And this is kind of a very, very small version of that, but the kind of background reasoning and the justification and the way it works is much the same. And which could mean that it's a kind of provision that the commission might see year over year in successive versions of HB2. So that's the update on the General Appropriations Act. Second, I'll go over to the Disclosure Act, which the commission authorized as a recommendation in its annual report at the end of last year. I'm very, very pleased to say that the Disclosure Act was introduced. It's HB 149. It's sponsored by Representatives McQueen, Garrett, and Townsend, and by Senator Tallman. It was introduced in the House, and it's been assigned to the House Rules Committee because it's not germane. It does not include an appropriation. And while the governor is supportive, the governor declined to give it a message for this session. But the fact that it's been introduced in the House, the fact that we worked with Legislative Counsel Service to improve the bill, to make it clearer, the fact that sponsors kind of worked on the bill to assuage certain concerns that they have, it means that we're in a really good position to push this legislation in the 60-day session when it will be germane. So that's the update on the Disclosure Act. And then last, there's two other bills to alert you to. They're both joint resolutions that would amend the Constitution. The first is HJR 9. This is a piece of legislation introduced by Representatives Figueroa and Eli. It would create in the Constitution an independent redistricting commission, and the State Ethics Commission would have an appointment role, much like the Ethics Commission had with the Citizen Redistricting Commission under the Redistricting Act. The appointment process is a little different than what you went through last June. So that bill has been introduced. It's had a hearing in House Government Elections and Indian Affairs, and it's likely to have another hearing in that committee before the end of the session. And then finally, there's another joint resolution, this time on the Senate side, sponsored by Senators Ivy Soto, Gonzalez, and Duhigg, and it's to amend the Constitution to allow the State Ethics Commission to have the power to set salaries for elected officers. That bill has received a due pass from Senate Rules, and it's yet to receive a hearing in Senate Judiciary. I have not appeared before any committee and don't really plan to do so with respect to that bill. This is the third time the commission has seen a version of that bill. it was introduced in 2020, 2021. And since 2020, the commission's position has been that the commission is just neutral as to that bill. And so I'm not appearing to provide even technical commentary on the bill. So that's an update in the session, how we're doing. And Chair, if there are any questions, I'd be happy to answer.
Well, let's see. Commissioner Baker, you have anything?
No, sir.
Thank you. Commissioner Bluestone?
Yes, thank you, Mr. Chairman, and thank you, Jeremy, for that summary. Just a couple of issues that I want to ask about. I know on budget, I remember reading that the LFC recommendation was the 93% of what you requested, but I think the executive and the DFA was at 100% of what we requested, and that there was some reference to being able to even increase the LFC 93% amount to the DFA full 100% amount of what we requested when it gets over to the Senate. Do you have any more information about that?
The only information I have about that, Chair and Commissioner Bluestone, is there was a conversation between a state budget division analyst and Secretary Romero about supporting the commission's request when the bill went over to the Senate side. And DFA will have a plan to try to see more of the executive recommendation on the Senate side of the bill. And the only way that the Ethics Commission at this point might play into that is if DFA's plan for amendments either in Senate Finance or on the floor includes the State Ethics Commission's request. But that's the most I know about it. I wouldn't bet the house on it. But if DFA is supportive of the commission's request on the Senate side, either in committee or on the floor, that'd be great. But the most I know about it is that Secretary Romero has indicated that they would be willing to have the commission's request as part of their plan. But this again was at the time of the HAFC hearing, and there's a lot of action between the first HAFC hearing and by the time the bill goes over to the Senate side. We're not a huge priority. It's not a lot of money, and the LFC recommendation is really, really good for the commission for FY23.
I understand that, and thank you. But typically it's easy, or not difficult, I shouldn't say easy, to get a senator to propose amendments to the House Bill 2 when it's over there. Do you have any plans to contact any member of Senate Finance or any other senator for doing any such amendment, even though it's not a big deal? Every little bit helps too.
It's not a plan I have at the moment. I will do it if you instruct me to do it. Senator Worth, I think, was supportive of an amendment a few years ago, but that we never saw that amendment come to fruition on the Senate floor with respect to the commission's budget. Again, the 93% of what the commission requested, I think, is a really strong footing for FY23. And at the moment, I haven't planned to ask a senator to get us up to 100%. I would encourage you to maybe we save that ask for a legislative session where we really need the increase. Again, 93% of what we requested, I think, sets the commission up for success in FY23.
Yeah, I'm not going to make a motion or anything to do that. I just, if you have conversations and it comes up and anybody asks about it, I think it's something to keep in mind. But I agree, it's not anything to push for, and I'm happy to defer to your judgment on that. The other issue I wanted to ask about is on the Disclosure Act. I remember that we also endorsed recommending the disclosure of legislators who have family members who are lobbyists, and to have them disclose that before votes in any committees or on the floor. And I don't know if that made it into the Disclosure Act as introduced. I see a sign here, connection is unstable. I apologize for that, and if you can hear me. But I just wanted to see either number one, if it's in the Disclosure Act now to provide for that disclosure of legislators who have family members who are lobbying on bills, and number two, whether or not it's in there, have you heard anything of any proposed House or Senate rules? Because I think they could do this, rules themselves to provide for that disclosure.
Thanks for that. And Chair and Commissioner Bluestone, that was discussed with, so it's not currently in the Disclosure Act as introduced. It was a conversation I had with Representative McQueen, the main sponsor of the bill. He thought that provision might be a non-starter for support of the bill, but it's a piece that we can pick up as we move toward garnering support and improving the bill for the 60-day session. And to your second question, I have not heard that there's any momentum in either chamber for making that rule change.
Okay, thank you very much, Chairman. That's all, Mr. Chairman.
Thank you, Commissioner Carruthers. Anything?
No questions.
Thank you, Commissioner Castillo.
Mr. Chairman, no questions.
Thank you, Commissioner Solomon.
No questions, Mr. Chairman. Thank you.
Thank you, Commissioner Villanueva.
Yes, this might be a little off topic, Jeremy, but the work of the SEC has had a significant impact on the budget of legal defense. Do you happen to know where they are with that? Have they received an increase? Are they going to receive an increase?
So Chair and Commissioner Villanueva, are you referring to the risk management division, the risk
Yes.
arm of GSD? I'm not sure. I'm not up to speed. Wendy, if you don't mind glancing at HB2 and to see if RMD is getting any significant increase in HB2 for the fund. Yeah, that's the best I can say right now, Commissioner Villanueva, is we'll give it a look.
Okay, thank you very much. Just a point of curiosity.
Thank you. Chair has no questions. Thank you, Jeremy. All right, we'll move on to the next matter, which is still yours for presentation purposes, Jeremy, and that's advisory opinion 2022-01.
Sure, thank you, Chair and Commissioners. So this is in page 9 of the public meeting materials, advisory opinion 2022-01. This is an opinion that was first issued as an advisory letter. Commissioner Bluestone requested that it be converted into a formal opinion for the Commission's review and approval. That's a process that we have under our Nmac rule provision regarding advisory opinions. The basic fact pattern is as follows. A member of the House is contracted through their local soil and water conservation district, they've received a contract to do project work. The project work is funded by federal funds and is located on federal land. The House member has no voice in determining the project funding or the project details, but the member wants to be certain that there's no conflict of interest and asked for an ethics opinion on the matter. The opinion roughly is as follows. This is an issue that's governed by Section 9A of the Governmental Conduct Act, which controls legislative interests in state contracts. It applies to any contract between a soil and water conservation district and a member of the House. Soil and water conservation districts are state agencies. And under the Governmental Conduct Act, to receive the contract, the House member would have to disclose their interest in the contract to the soil and water conservation district, which is probably easily done. It seemed from the fact pattern they already know about it. But more importantly, the soil and water conservation district has to award the contract in accordance with the procurement code without resorting to the provisions of the procurement code that allow for a sole source contract or a small purchase contract. So that's one of the main constraints with respect to contracts between legislators or their family members or their businesses that they have an interest in and state agencies. And then the other significant piece that this opinion provides is it clarifies that even if state agency projects are funded by federal funds, the state procurement code still applies. In instances where state agency projects are funded by federal grant money, in those instances, both the state's procurement code and any relevant federal procurement law applies. And if there's any conflict between the two, then the federal law trumps. But it's important to remember that even if it is funded by federal funds, the state procurement code applies. And so that Chair and Commissioners is a brief survey of the advisory opinion, and I'd ask you to adopt it.
Okay. Let's take a motion in a second and then open it for discussion. Is there a motion in a second?
So moved.
Okay, discussion, Commissioner Baker?
No, other than I thought the opinion was very well written, easy to understand. And for what it's worth, I agree with the recommendation, I agree with the analysis.
Thank you. Commissioner Bluestone?
Thank you. I agree with and I think it's just good public policy, public service for us to convert informal opinions that have some general application, like I believe this one does, into formal advisory opinions. It gets put on, there's more availability to the public to read these and understand them, and particularly to the legislators, in this particular opinion to whom this applies. I think it's a helpful exercise. I'm glad you converted it into a formal one, and I'm happy to support it. Thank you.
Thank you. Commissioner Carruthers?
Well done.
Thank you. Commissioner Castillo?
I agree. It's very well written and it gives good direction, and I support it.
Thank you. Commissioner Solomon?
No questions. Well written. Thank you very much.
Thank you. Commissioner Villanueva?
No questions. Thank you.
Thank you. And the chair would echo, I mean, I've read a lot of stuff over the years that some is on drier subjects than this, although not many, but I thought this was exceptionally well written. And dare I say, nah, I won't go that far. Anyway, well done. Good job.
Okay, thank you, Chair.
There's a motion in a second. Commissioner Baker,
I vote to approve.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Let the opinion issue. Thank you. The next matter is advisory opinion 2022-02.
Okay, thank you, Chair and Commissioners. This advisory opinion is one that deals with the Campaign Reporting Act. It's one of our Campaign Reporting Act advisory opinions. It came in from a request from someone that has authority to request a formal opinion from the Commission. There's two questions that are presented, and I'll just go through each question followed by its answer before moving on to the next subject matter. So the first question is as follows: a candidate sought a municipal, school district, or special district elected office, and the candidate received contributions to support the candidate's election to that office. Those are non-CRA offices. Does the Campaign Reporting Act prohibit the candidate from retaining and using those contributions to support the candidate's subsequent campaign for an office covered by the CRA? So suppose that the candidate that ran for municipal, school district, special district office lost, and then now they're running for an election covered by the Campaign Reporting Act, such as a county election or a statewide election. Can they use the contributions they received when they were running for mayor or school district in their CRA election? That's the question presented. And the answer is, so the question is, does the CRA prohibit the candidate from retaining and using those funds? The answer is no. That's not prohibited by the CRA. But really what controls here is whether or not there is municipal law, relevant municipal law, or law pertaining to the specific non-CRA election that would allow that candidate to convert the contributions they received to personal use and then use them in a CRA election. So for example, the city of Albuquerque and the city of Santa Fe do not allow candidates for municipal Albuquerque or municipal Santa Fe elections to convert contributions they received into personal use, which then would allow them to make a contribution to their own campaign when they're running for state election. So it wouldn't be allowed for a Santa Fe or an Albuquerque municipal former candidate, but that's a matter of kind of local law, and it's not something that the CRA itself requires. So the Campaign Reporting Act generally allows this. It allows for a municipal special district school member candidate to convert those contributions to personal use and use them when they're running for a statewide election. And I think that the School District Campaign Reporting Act explicitly permits it for school districts. So, basically the opinion is that this is perhaps it's a lacuna in the law. It's a gap in the law, but it's not something that the CRA prohibits. So that's the quick answer to the first question. The second question is a variant. A municipal judge intends to run for county office in 2022 and seeks to transfer contributions received as a candidate for judicial office to a newly formed campaign committee that supports his candidacy for county office. Does the CRA prohibit the transfer? The answer to that question is yes. The Campaign Reporting Act incorporates the Code of Judicial Ethics, and the Code of Judicial Ethics requires that a judicial candidate, after the campaign is over, has to return those contributions, and therefore that judicial officer could not use those contributions, convert them to personal use, and use them for the county election. So because the Code of Judicial Conduct prohibits it, the CRA incorporates the Code of Judicial Conduct, and the CRA prohibits it. That's a quick overview of the advisory opinion 2022-02. And Chair, I'd ask that the commissioners adopt it.
Thank you. Is there a motion and a second?
So moved.
So moved.
Thank you. Commissioner Baker, anything?
No, I just want to thank Jeremy for using the word lacuna. I just had to look it up, and I now have another word in my vocabulary.
Will you
Mr.
email
Baker,
that to the rest of us, Jeff, your discovery?
Lacuna means interval or gap.
Okay. I thought it was a community slightly west of Albuquerque, but I guess Commissioner Solomon would be better able to speak to that. Thank you, though, Jeff, for your concern. Commissioner Bluestone?
No questions, just one quick comment. Again, very well done, Jeremy. But in addition to Jeremy's oral description, the opinion also says that the judicial candidates have the option not only of returning their excess funds to the campaign contributors on a pro rata basis, but they can also donate those funds to a charitable organization or to the state of New Mexico. And that's in the opinion, but it just wasn't what Jeremy in his quick summary stated. And I just wanted to mention that because I think it's kind of interesting. But again, well done. No questions. I'm happy to vote for it.
Thank you. Commissioner Carruthers?
Commissioner Bluestone, that was a gap. And what was that term?
A lacuna.
Yeah, that was a gap.
Commissioner Castillo?
Again, I want to tell Jeremy, I think this is well written, and this kind of direction I think is very important for candidates, and it gives them the information they need when they're deciding what to do with their funds. So well done.
Thank you. Commissioner Solomon?
It's always great to see words that we can learn from or learn about. There's another one, I think anodyne or something like that, that I had to scurry over to the dictionary for, looking for it, or in Black's Law Dictionary as well, and still couldn't find it. So I'm for it. Yes.
Thank you. Thank you. Commissioner Villanueva?
No questions.
Thank you. All right. Chair has no questions, so we'll put it to a vote. As we have to do formally, I'll do a roll call vote. Commissioner Baker,
I vote yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva. Judy?
Yes.
Thank you. I'm sorry, I didn't hear you. Chair votes yes, let the opinion issue. Okay. The next matter is item number 4, process regarding general counsel activities after discovering an unalleged violation of an ethics law during an investigation. Number 4, and it has Stuart and Jeremy as the presenters. So gentlemen, take it away.
Okay, thank you, Chair and Commissioner Bluestone. So this is a question that Commissioner Bluestone raised since the last meeting, and it raises a pretty important issue that the Commission is likely to see year after year in the course of its administrative cases. So complainants file administrative complaints with the Commission. Oftentimes they're pro se. They will allege certain violations in their complaint of various laws that the Commission has jurisdiction for. Sometimes laws the Commission doesn't have jurisdiction for. Where a complaint is within the Commission's jurisdiction, the General Counsel will conduct an investigation. And in the course of the General Counsel's investigation, it might be the case that the investigation uncovers a claim that was not alleged by the complainant, but nevertheless, it looks as though the evidence that's arising in the investigation would indicate that another law within the Commission's jurisdiction has been violated. So it's not within the 4 corners of the complaint. It's not really in the administrative case, but it's kind of come to the fore in the investigation, and that raises a question for what the Commission should do in those instances. And the point of this discussion, and I think it is just a discussion topic at the moment, is to think about what the Commission ought to do, and both the staff and the commissioners. And I propose roughly the following. When that happens, I think the GC or the deputy GC investigating the case needs to alert the executive director. The executive director needs to alert the Commission in the form of a memo, and the Commission would review that in an executive session, and essentially be in the position to do 3 things: do nothing, file its own administrative complaint, or file a civil action to remedy the violation. And so that's kind of the most I've thought about the issue. It's one that has come up already. We're likely to see it come up again and again. And in some ways it links to kind of larger questions that I've been mulling over for how to reform the administrative complaint process in years to come, things that would require a statutory amendment. But it's an issue that Commissioner Bluestone wanted to discuss. And so I think I've introduced it, and Commissioner Bluestone, if there's anything you'd like to add, please do.
Thank you, Jeremy. I think that's a good summary and a good proposal. This came up, as you all are probably aware, in the most recently publicly disclosed complaint in which the General Counsel found probable cause to proceed with a hearing and noted in his finding that he thought there was a violation of another law, the Lobbyist Regulation Act, over which we still do have jurisdiction, but decided not to go forward on that matter because it wasn't alleged in the complaint. And I think that it's appropriate, as Jeremy has discussed, for us to consider how we want to handle such matters as they may well continue to arise. And I think that the format he's proposed is a sensible one, rather than having a hard and fast rule that they either all will not be looked at or that they all will be prosecuted separately, is to refer it to us and let us look at it and really decide what justice requires. And I think Justice Castillo may have some comments on her understanding of what the courts have done in similar circumstances to ensure that justice is served rather than being limited to what is confined in the allegations of the complaint. But I'm pleased with the proposal that Jeremy's described, and I do think it's worthy of all of our consideration. I don't think it requires any action today, but I thought it was important for us to consider the issue and to be aware of options we had. And I think Jeremy's proposal is a good one for us going forward. So thank you.
Thank you, Stuart. Anybody else want to weigh in on this? We'll start just informally. Jeff?
No.
Okay. Stuart, you have. Governor?
I think they ought to be pursued. I don't think they ought to be set aside simply because it wasn't included in the original document or complaint. And how you do that, Jeremy's proposal seems sound to me. I think it would be dependent upon what's found along the way, so that the severity of the complaint might be the driver in this particular case.
Thank you. Commissioner Castillo?
Yes, I like Jeremy's approach. My recollection, and you would know more about this, Judge Lang, in the civil area, if things come up and there are other counts, the parties can go ahead and amend the complaint and go along. So there's a procedure to add them in, but there is a procedure, and it's really not the judge that does the amendment. In our case, though, the commission does have the ability to go ahead and file its own civil complaint. So that's why that's one of the options.
Right.
And then, of course, when you get to an appeal, if it's not appealed, then we normally, the Court of Appeals and the Supreme Court doesn't look at the issue unless there's a question of justice. So I like the idea of taking these one by one and deciding what needs to be done depending on what the evidence is.
Right.
Thank you.
Thank you. Commissioner Solomon, anything?
Initially, I like the proposal, but I'd like to study it more, and I think we have time to do that. Thank you.
Thank you. Commissioner Villanueva?
No questions, thank you.
Thank you. Nor do I, but it makes sense to have a process that allows for all possible looks at it, and the flexibility that's proposed here makes sense to me. So thank you, guys, and we'll look forward to something down the road that seeks commission approval. Number 5, Resolution 2022-01 relating to complaints against notaries. Jeremy?
Okay, Chair and Commissioners, as you know, the responsibilities of this commission are growing, and the way that they're growing the most quickly is with respect to a newly granted authority to deny, refuse to renew, revoke, suspend, or impose condition on a commission as a notary public. The revised uniform law on notarial acts became law on January 1st of this year. And previously, under the Notary Public Act and the Uniform Law on Notarial Acts, the state agencies that had a role in reviewing alleged misconduct by notaries public were fractured among a few different agencies. Ultimately, the power to sanction a notary public vested in the governor, and the governor under the Martinez administration issued an executive order that kind of farmed a lot of that work out to the Regulation and Licensing Division, but the Attorney General's office also had a role with respect to the preparation of notice of contemplated actions. And notary publics, unlike other licensed professions in the state of New Mexico never had their own kind of board, never had, unlike the medical board or the dentistry board or the board of architects. So there was always kind of a question of where to house the review for misconduct by notary publics. And that question, I suppose, has been settled now. It's whereas under the Notary Public Act, it was under the governor, that has changed. And now the State Ethics Commission is the state agency that has the authority to review alleged misconduct against notary publics and to issue remedies and sanctions against persons with notary public commissions. And the location of that authority is section 1414A22. And it is as follows: the commission may deny, refuse to renew, revoke, suspend, or impose a condition on a commission as a notary public for any act or omission that demonstrates that the individual lacks the honesty, integrity, competence, or reliability to act as a notary public, including, and then it lists 10 different instances of conduct that could support a remedy. So that's kind of a large grant of a new grant of authority to the commission, and it brings within the commission's purview a new set of folks, notaries public. So in order for the commission to legally exercise this power, there needs to be some procedures. And in the future, I think it would behoove the commission to conduct a rulemaking to formalize the rules by which notary public complaints against notary publics will be adjudicated, which a set of rules that guide the commission in its remedial power, its sanction power with respect to notary publics. But before we get there, the commission has to have some rules now, because RLD has sent over a half a dozen notary public complaints that they did not complete, and that are now for the commission to resolve. And since January 1st, the commission has received other complaints against notary publics. There's a question whether or not this docket is going to outpace the ethics docket. I'm not sure. We'll have to see. But it's a new docket. The commission needs to enact new procedures for these cases because they're in the door. We have them now. So on December 27th of last year, I issued a memorandum that sets forth two sets of procedures. One set of procedures for complaints that were filed on January 1st or going forward, and then another set of procedures for complaints that came over from RLD. And the reason why the memo kind of sets forth two sets of procedures is because the complaints that were filed last year or before last year that were with RLD and were subject to the governor's executive order for how those complaints would need to be handled, the Ethics Commission's procedures would need to follow those. There's an article, there's a provision in the Constitution that pretty much says you can't change the rules of procedure in a pending case. The Constitution limits the legislature's power to change the rules of procedure in a pending case. And the courts have interpreted that constitutional provision to apply to administrative agencies. So administrative matters, once they're filed and are pending, you can change the rules of the game on them. So this memo has two sets of procedures, one for the cases that came over from RLD that kind of roughly tracks the procedure that RLD was using. And then another procedures for notary public complaints against notaries public that were filed on or after January 1st. And so, commissioners, what you have before you for this agenda item is a resolution that adopts those procedures and kind of ratifies the commission's use of those procedures. The resolution is at page 20 and 21 of the public materials. And then the memorandum itself is Exhibit 1 to the resolution, and it's at pages 22 to 27 of the meeting materials. And so that is the presentation before you. Chair, if you would like me to go through the procedures themselves, I'm happy to do so. I'm not sure it's necessary. It's all in the memo, but also happy to answer any questions.
All right, well, let's entertain a motion in a second, and then we'll move to discussion of it. Is there a motion in a second?
Second.
Move
We'll
adoption of the resolution.
And I'll second it.
Thank you. Okay, it's been moved and seconded. Any discussion?
I have a question. It might be in here and I've overlooked it, but Jeremy, who has the burden of proof and what is that burden?
Okay, thank you, Commissioner Baker. Chair and Commissioner Baker, on that, with respect to the complaints that are filed after January the 1st, the way it works is as follows. I suppose who has the burden of proof is ultimately the commission staff. It's the commission staff that initially would look at the complaint, would make a recommendation either to the commission to either not take any action or take some form of action that is not an adverse action on the commission's on the Notary Public Commission itself. So any action that's a warning or no action at all, or in the alternative, moving toward taking an adverse action on the commission as a notary public. And that would require a notice of contemplated action. A notice of contemplated action would go to a hearing if the notary public wanted a hearing, because here we're under the traditional constitutional due process constraints of notice and public hearing for any adverse action on a commission as a notary public. But it's going to be the commission staff who makes the initial recommendation to the commission if the recommendation is to not proceed to a notice of contemplated action. But if the decision is to proceed to a notice of contemplated action, then it would go before a hearing, and it would be the commission staff that's basically prosecuting the case. What we've done here is we've tried to put together a procedure that looks more like ordinary administrative procedure than what the State Ethics Commission Act requires for our ethics cases. And so it's going to be the commission staff that takes a look at the complaint. It's going to be the commission staff that issues a notice of contemplated action. It's going to be the commission staff that would prosecute the matter before a hearing officer. And that's, so I guess the short answer to your question is the commission staff has the burden of proof.
And what is the burden?
So the rules of evidence don't apply. I imagine that the burden is going to be a kind of preponderant civil standard. And what would have to be shown is, again, under 14A22 is an act or omission that demonstrates that the individual lacks the honesty, integrity, competence, or reliability to act as a notary public, including. So I think the way that this would work is what has to be shown is evidence supporting such an act, a preponderance of the evidence supporting such an act. But again, in this administrative form, like many of the administrative fora in New Mexico, the rules of evidence don't apply.
So I'm trying to imagine a situation where there'd actually be a hearing with respect to a notary. An obvious one would be somebody says, that's not my signature. Another one would be, that's not my grandmother's signature. And then the notary says, well, yes, it is, because I was there and I saw grandma sign it and I notarized it. In that type of back and forth, what would the commission have to prove in order to be able to sanction that notary?
Well, there might be cases. Let me kind of adjust the hypothetical to make it more answerable. There might be cases where a notary public, there's a complaint against a notary public that the notary pressured the signer to sign the document because somehow the document benefits the notary public. The transaction being notified somehow redounds to the interest of the notary public themselves, and there was pressure, but perhaps the notary public denies that, disputes it, and there might be a question of fact. It's not in every of these cases do I think that there's going to be hard questions of fact, but there will be notary public cases in which questions of fact arise. So is that helpful? Becky, do you have anything to add on these cases with respect to when questions of fact might arise or not?
No, I think you've addressed it.
Okay. Is
Let
that
me just-
helpful, Commissioner Baker?
Yeah, let me just suggest, and I don't want to overcomplicate this. If there is a disputed fact, if you were to add a sentence to this resolution, that in the event of a disputed fact, the commission has the burden by a preponderance of the evidence to prove that the fact is more likely than not. I'm just trying to think of situations in which there's really going to be a hearing with respect to a notary. Most of these things, I think, are going to be resolved pretty informally.
Let Chair and Commissioner Baker, let me ask Becky, is that ordinarily what would be included in a notice of contemplated action that would be sent out prior to a hearing?
Yeah, so under most of the other administrative professional licensing types of cases are handled under the Uniform Licensing Act. And so this is actually a very similar type of framework to that, but our notary publics don't come under that act. But yes, it is typically handled with the preponderance of evidence, more likely than not. And so I don't think it would be a problem to add it.
So thank you, Becky. Chair and Commissioner Baker, I think that addition probably makes the most sense in paragraph 8 of the memorandum, which addresses a hearing officer holding a hearing to determine whether or not the recommendations in the notice of contemplated action should be adopted, modified, or set aside. And the hearing officer would need to make that determination based on the preponderance of the evidence offered in the hearing, something along those lines.
Yeah, thank you. I think that would be helpful.
Okay.
Thank you. Anything else, Jeff?
No.
Thank you. Commissioner Bluestone, anything?
Thank you, Mr. Chairman. I just want to point out one thing and then raise one issue. The powers that we have as the commission now are different and exceed the powers that the governor had to discipline notaries for violations, infractions, whatever. We have an additional power, at least one additional power, of being able to suspend a notary's license for, I guess, whatever period of time we would determine might be appropriate. But I think that that's an important additional authority that's granted to the commission as we review cases that involve notaries that approved and put their signature and seal on documents where that kind of thing. So I just raised that as what I think is a significant point to keep in mind. Secondly, what I find really curious in new notary law is that it automatically allows any attorney to notarize documents. If you're a licensed attorney, now you can be a notary as well in New Mexico. And we all know how many complaints there are about attorneys. And I have a feeling that we may find ourselves dealing with a new can of worms here than has been dealt with. And the one comment that I wanted to offer on that is that if a lawyer is involved in an inappropriate action involving him being a notary, and I don't know if they're going to start having seals and doing stamps and all that kind of stuff too, but we may want to work out something with the disciplinary board of the State Bar of New Mexico, because they're the ones that have the authority attorneys for misconduct and other infractions. And so it's something we and Jeremy, you may just want to, if you haven't already, on how we might want to work out a memorandum of understanding or an agreement. If we start getting complaints about lawyers as they execute their newfound notary authority, I mean, some education that we needed for lawyers about how to use this authority. But I see this as a whole new operate here for the notary world in New Mexico. I'm not sure if it's done in other states. I just don't know about it, but I thought it was a curious feature of this new law.
Good point. Thank you. Anyone else?
I'd just like to know if I've been a notary for the last 10 years, and now all of a sudden, as a result of this law going into effect on July 1st, how's my life going to change? And if it's going to change any at all as a result of this new arrangement, is anyone going to bother to educate notaries about the changes so that they can be comfortable pursuing their careers of notary?
So Chair and Commissioner Carruthers, to that question, if your commission as a notary public was live, hadn't expired before the 1st of January, the commission you had under the Notary Public Act is now a commission that you have under this statute, RULONA, the Revised Uniform Law and Notarial Acts, and now you're subject to the power of the Ethics Commission if someone alleges that you have engaged in some misconduct with respect to your commission as a notary public. So your life changes in the respect that now it's not Governor Carruthers, but Commissioner Carruthers that has some authority over your commission as a notary public. And then with respect to the education piece, the Secretary of State's office is the agency that has the responsibility to educate notaries public on their duties under the Revised Uniform Law and Notarial Acts, and it's still the Secretary of State's office with whom a notary public files and becomes a notary public.
Thank you.
Anyone else? Celia, Commissioner Castillo?
Just a couple of things. First of all, we have, if for the complaints that have come over, okay, from the governor's office, we have to follow the same process. But as far as the discipline is concerned, we have more options than the governor did. Is that correct? Because we can suspend, and the governor didn't really have that power.
Chair and Commissioner Castillo, I believe that's correct. The only caveat to add is that the commission of the notary public needs to not have expired in the past year, but still be a commission that didn't expire and kind of carries over into the new year and is now subject to RULONA, and thus the commission's power under RULONA.
Okay, thank you. And then my second question has to do with the training. Is there any kind of coordination between us and the Secretary of State with regard to the complaints? Because if there's an area that seems to be repeating itself, they should know about this to do the training.
Chair and Commissioner Castillo, so we are very much in communication with the Secretary of State's office about RULONA. It's part of the process to where when we receive a complaint against a notary public, one of the first things we do is ask the Secretary of State's office for that person's file as a notary public. There are also cases that the Secretary of State's office held until the commission had the power to act under RULONA, and the Secretary of State's office has kind of sent cases the commission's way. For what you're referencing as problems that are likely to repeat and need some addressing via training, that I'll say that we will address that. We have monthly meetings with the Secretary of State where we go over kind of everything that we're doing together. And if and when these instances arise, it'll be put on that agenda.
Okay, thank you.
Commissioner Solomon, anything?
No, it just seems like a bear to be dealing with Rulona. It almost sounds like a mythical figure now.
Like a lacuna.
Yeah, kind of like Lacuna. But no, I'm just interested in seeing how this evolves. You know, one of the things that when I've had to use a notary public in the past for different things, I often wonder how they set their fees, and so that's just a question. You know, I'm not sure how that is all done because I don't have any kind of comparative rate schedule for them or anything like that I've been able to look at. So I'll just leave it there. I appreciate the opportunity. Thank you.
Thank you. Judy, anything, Commissioner Villanueva?
Oh, it's very educational to me. It's going to be very interesting.
Thank you.
So,
And from my perspective, it makes a lot of sense because there's more availability if a lawyer, by virtue of his or her having become a member of the state bar, has those same abilities. The question I have has to do, they're members of the bar, and the disciplinary board is sort of a state agency, but really not. So there's kind of an interesting jurisdictional thing there, although lawyers, I think, would probably be more concerned about their disciplinary board than the ethics commission in this sense, given the livelihood. But it's an interesting point to raise. But there's a motion and a second to adopt the resolution. The suggestion, which everybody seems to agree with, regarding adding a sentence on the burden of proof being a preponderance of evidence, is contained in Jeremy's memo, and Jeremy has represented that he will modify the memo. So I don't think that requires a modification of the motion in the second. But if anybody feels otherwise, we can go through that formal exercise. If not, I'll call the question. So, Commissioner Baker,
I vote yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Thank you. Thanks. That will be kind of interesting to see what plays out under that. All right, now we will, upon an appropriate motion and second, to go into executive session, do so with a 5-minute adjustment period, or shall we say. So is there a motion and second to go into executive session?
So moved.
All right. And
Stand by. I'll put everybody into breakout rooms.
thank you. Is there any, no opposition? None. Okay, executive session, and we'll take a short break. 5 minutes. Okay, are we ready to proceed in open session?
Well, you have 2 Rs and 2 Ds, but I think we're still waiting on Ron and Celia, Commissioner Solomon and Castillo.
Okay. There's Commissioner Solomon. And there's Commissioner Castillo. Okay. We are back in open session, and agenda item number 8. Jeremy, if you'll take us through that.
Okay, happy to do so. Chair and Commissioners, these are commission actions on administrative matters. I'll just go through them. So in an administrative complaint number 2021-010, the staff seeks a motion to dismiss the appeal.
Is there a motion and a second?
So moved.
Second,
Thank you. Any discussion? Hearing none, we'll call the question. Commissioner Baker,
I vote yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
yes.
Commissioner Solomon,
No.
Commissioner Villanueva,
Yes.
and chair votes yes. Okay, motion carries. Next item.
Okay, commissioners, this is an administrative complaint number 2021-12. The staff seeks a motion to extend the investigation period of this administrative matter for another 90 days.
So moved.
Second,
Thank you. Any discussion? Hearing none, let's call the question. Commissioner Baker,
yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes, motion carries. Next item.
Okay, thank you, Chair. Commissioners, in administrative complaint number 2021-20, the staff seeks a motion to dismiss the complaint because the complaint was filed pseudonymously.
Anonymously. Yes.
So
I don't
moved.
like that word.
There's a motion. Is there a second?
Second,
Thank you. Commission, any discussion? Hearing none. Commissioner Baker,
yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes, motion carries.
Okay, thank you, Chair and Commissioners. In administrative complaint number 2021-29, the commission seeks a motion to dismiss the complaint for lack of personal and subject matter jurisdiction.
Thank you. Is there a motion, a second?
So moved.
Second.
Thank you. Any discussion? Hearing none, I will shut my phone off. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes.
Okay, thank you, Chair and Commissioners. In administrative complaint number 2021-37, the staff seeks a motion that the commission dismiss the case pursuant to section 11934.4C because the Secretary of State has certified voluntary compliance with the Campaign Reporting Act.
Is there a motion, a second?
So moved.
Thank you. Any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes, which leads us back to go. F.
So thank you, Chair and Commissioners. In administrative complaint number 2021-39, the staff seeks an order dismissing the complaint for lack of jurisdiction and referral of the matter to the Carlsbad Municipal School District.
Motion a second.
So move.
Second,
Thank you. Any discussion? Hearing none. Commissioner Baker,
yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. Thank you. Motion carries.
Okay, thank you, Chair and Commissioners. In administrative matter 2022 NPO4, In Re Notary Public Commission of Lakeisha Nicole Stewart Childs, formerly known as Lakeisha Stewart. The staff seeks an order dismissing this matter because the notary no longer lives in New Mexico. Their notary public commission has expired, and to refer the matter to the Arkansas Secretary of State.
Is there a motion and a second?
So moved.
Second.
Thank you. Any discussion? Hearing none. Commissioner Baker,
Yes.
Mr. Bluestone,
Yes.
Commissioner Carruthers,
Yes,
Commissioner Castillo,
Yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Motion carries. And NPO 6.
Thank you, Chair. Commissioner Castillo, would you like to make the motion or shall I?
doesn't make any difference.
Okay,
Go ahead.
okay. Well, in Administrative Matter 2022, NPO 6, In Re Notary Public Commission of Cairo, the staff seeks an order instructing the staff to send the notary a notice of contemplated action.
Okay, is there a motion and a second?
And I so move.
And I second.
Thank you. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone. I'm assuming since he moved it, he will approve it, but I do need to hear his vote. Or raise your hand, Stuart, if you're compromised. That's a yes. Okay. Commissioner Carruthers,
yes,
Commissioner Castillo,
Yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes, motion carries. Thank you. Next item is number 9, resolution.
Of a notary. We're on number 8C, Chair, notary.
I'm sorry, I'm working off an old, the earlier copy of the agenda, my fault, sorry.
So no problem, in administrative case number 2022, Notary Public 07, In Re Notary Public Commission of Timothy Rivera. The staff seeks a motion that the commission dismiss the complaint because the commission lacks authority to take action against a commission as a notary public that expired before January 1st, 2022, as did the commission of Mr.
so
Rivera.
moved.
Second, anybody?
second.
Thank you. Moved and seconded. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes,
Commissioner Castillo,
Yes,
Mr. Solomon,
Yes.
Mr. Villanueva.
Yes.
Chair votes yes, motion carries. Now, can we go to resolutions, Jeremy?
Here, I think we, on the updated agenda, I believe the next item is discussion of next meeting.
Okay, so we've already done that. Okay, never mind. And I apologize. I prematurely printed. The next meeting would be set for the first Friday in April, which by my calendar is April 1st. Without comment on that, I will ask if there's anybody that has a good reason why we should not have it on that day.
Don't you have to make a comment?
I don't think I need to. Okay, so we'll see you all. The next meeting will be scheduled and will be noticed for April 1st, 2022. Public comment. I will leave that to the
Sonny's turn this time. He's the host.
Sonny.
Yes.
If any member would like to make public comment, please raise your hand at this time.
That's right. Currently, there are only 12 participants. There's only one member of the public attending, named Rich. Rich, if you'd like to make a public comment, please indicate so by raising your hand. There's a button on the bottom of the screen. Otherwise, feel free to.
You know, I don't know if you can raise your hand on this screen. I don't know what's going on here, but.
You can, it's under reactions.
Okay, I see. Raise hand.
Moved it.
Okay, Chair, seeing that as there's no public comment at this time, I think we're on to the next item.
All right, the next item by my calculation, unless I'm misreading it yet again, is adjournment.
Correct.
Okay, but before doing that, in the event that we don't see Sonny again, I want to thank him in front of everybody for his extraordinary service in getting us up and off the ground, and otherwise missing his genial company, good nature, and extraordinary skill set. Best of luck to you. The United States Air Force is very, very lucky.
Thank you, sir. I appreciate it.
Don't move.
All right. All right.
I'll miss you, Sonny.
Thank you. I'll miss all of you for sure.
Thank you. All right. So everyone, please be well, and we'll see you in a couple of months. Meeting adjourned.
Thank you very much.
Thank you.
Thank
you.
you.
Everybody.